Evaluate the view that the US Constitution is a living document. Ever since Professor Howard McBain, penned his controversial book, The Living Constitution, in 1937, opinion has divided between those like McBain, who view the Constitution as an organic body that changes to reflect the needs of society in which it operates, while still retaining the framework established by the Founding Fathers in 1787, and those who counter this view, notably Antonin Scalia, current Supreme Court Justice. This view took hold particularly in the 1970s, when the Supreme Court declared the death penalty a cruel and unusual punishment and declared it unconstitutional, and in 1973 was controversially declared that abortion and any laws restricting it technically were unconstitutional. Scalia refutes the living constitution notion as the work of judicial activists, particularly some of his fellow judges like Stephen Breyer, and instead referred in an interview in 2009 to what he preferred to call the dead constitution. For critics such as Scalia, the living constitution is wrong-headed, because whilst ordinary laws when passed mean the same years later, the activist philosophy deems the constitution to be open to regular morphing, according to what the Supreme Court say when looking at the 8th Amendment, and refers to the evolving standards of decency that marks the evolving of a modern society. Though disappointed, Scalia advocates that as a philosophy, the living constitution has come to dominate legal and political thinking, and even become the mainstream view of the American public. He sees the triumph of the living constitution as being one based upon the fact that it seduces lots of judges because it gives them real power. Thus, Scalia, a critic of the living constitution, still sees it as a dangerously pervasive doctrine. He is joined in his view by academics like Ed Vieira, who sees the living document view as putting forward a political slant upon the way the Constitution should be interpreted. He sees it as having a fixity of meaning, and says to adopt a living view is to suggest that the framers are not rational human beings, and in so doing we are trashing the Founding Fathers. He contends that the most blatant abuse is that the living Constitution has allowed the Congress, or more like the Supreme Court, to actually kill off Article 5. In essence, he defends the original intent by arguing that it is Article 5 that outlines the formal procedure of amendment that is the only legitimate means to add life to the Constitution, as it is based upon a national consensus and not the whims of a majority of 9 judges. The criticism of the living Constitution often is focused by the view that judicial activism has led to judges supported by academics and politicians changing the meaning of the words of the Constitution and making the laws say what you think it should say, rather than submitting to what it says. Economist Thomas Sowell was annoyed by the Living Constitution Brigade and accused them of disregarding the process of amendment laid out in the Constitution, Article 5, simply because they wanted to make changes. For him and other critics of the McBain term, it was no surprise that such playing fast and loose with the Constitution should happen in the 1930s, at a time of enormous social and political upheaval, and in Franklin Delano Roosevelt, a president who was popular, was threatening to pack the Supreme Court in an effort to enhance federal powers. Thus set the dispute between the Conservatives and Liberals, strict and loose constructionists, over the original meaning of the Constitution. Dr. Mark Graber from the University of Maryland does not view the original intent versus living Constitution debate as particularly relevant. To illustrate his disposition to the living Constitution, he points out how Congress was given power to regulate interstate commerce in the Constitution, and some 60 years later along comes the train, which totally changes how goods and services can be moved between the states. Since society changes, argues Graber, the Constitution must change to accommodate such changes. He goes further to challenge the originalists by saying that there is as much point asking what George Washington would make of the hula hoop and the internet in relation to free speech as asking him to comment on the hula hoop. In simple terms, writers such as Gerber reject literal interpretation of the Constitution on the grounds that if this was the case, then Congress could make any law that did not explicitly violate a part of the Constitution. In this situation, a state could conceivably make a law to take away every couple's second child, and the Supreme Court, acting upon original intent, would not be able to counter such an obvious legislative tyranny. An original intent or fixed constitution believer, John McGuinness, argues that sexual mores are an excellent example of how it does not need the formal process of Article 5 or the Supreme Court to change the Constitution. The real thing that's changed sexual mores in this country is the structure that the framers gave us. In other words, the fixed, not living document. That's what he calls federalism. It means that people, say in San Francisco and New York City, have had, for most of the century, very different morals than other people in other parts of the country. A sense that you could have much more tolerance and still have a very well-functioning society. McGuinness comments, and they got around, wrote about that and actually have won. Not, I think, because some new cases from the Supreme Court, but because they persuaded people by a process of competitive federalism. They've demonstrated in states what works, and that catches like wildfire to other states. And that's a mechanism of change that's built into the Constitution. Of course, the debate also pitches liberals against conservatives. For liberals, the judicial activism of the 1950s onwards was a desirable part of the living Constitution, as the Warren and then the Burger courts challenged the segregationist policies of the states and advanced civil rights. However, even moderates who welcomed such judicial interpretation of the 14th Amendment that ended separate but equal were concerned by the way it would stretch to find a new living equality clause in the 14th Amendment to give women a right to an abortion. Conservatives like Scalia say that they have no objections to abortion rights per se, but feel that this is not the Constitution, or in the Constitution, and that Justice Blackmun, who wrote Roe v. Wade, was breathing life into its inert pages, as Floyd Abrahams, University of California, said. Scalia sees the living Constitution only in terms of Article 5 and the strict amendment process. In that sense, he accepts a gradualist, life-adding role via the obstacles of the amendment process. Scalia is a strict constructionist, with the accent on the strict, but he still accepts that the Constitution can change. He simply does not accept that this should be what he calls legislating from the bench. He recently said, the following about the Constitution: "My Constitution is a very flexible Constitution. You want a right to abortion? Create it the way all rights are created in democracy. Pass a law. That's flexible." Yet even conservatives are accused of applying the same judge-made interpretation to protect or promote their conservative values. Thus, in Columbia v. Heller in 2008, the Supreme Court ruled for arguably the first time in history that the Second Amendment did actually stop state regulation of handgun ownership. In the past, the original intent had tended to discourage the court from becoming involved. Indeed, the whole wording of the Second Amendment, a well-regulated militia, being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed, has come under scrutiny, since was it the intention of the framers to simply allow for militias to be established, protect the new republic, a collective right, or was it an individual guarantee to be allowed to own guns? Surely any interpretation of such an ambiguous amendment leaves it open to the idea that the Supreme Court has to give meaning or life to the Constitution. As the point above illustrates, a significant section of the Constitution is written in such broad and ambiguous language, cruel and unusual, for instance, and thus makes it possible to add life to it. This is the reason why the Supreme Court and the judicially active judges reason that the Constitution is living, and they must view it in terms of what is in the best interest of a changing society, and not in terms of what the Founding Fathers meant over 200 years ago in a male-dominated, slave-owning rural society of some 5 million people, compared to the multi-ethnic 320 million urban advanced capitalist society of 2011. However, for most of the 19th century, it was the rigid or original intent that dominated. Joseph Story, a 19th century legal scholar, considered the Constitution to have a fixed, uniform, permanent construction. It should not be dependent upon the passions or parties of particular times, but be the same yesterday, tomorrow, and forever. This view itself, challenged as social Darwinism, gained appeal, and Supreme Court Justice Oliver Wendell Holmes started referring to the Constitution being considered in the light of our whole experience and not merely what it said 100 years ago. In evaluating the Constitution, it might be stated that in the 19th century it was a set of immutable laws like Newton's law of physics. By the 20th century and 21st century, it better conformed to Einstein's laws of relativity, and any views of it depended upon the perspective of the observer. The key change has given a potential power to the judges, and as such they really decide if the Constitution is fixed or flexible, living or dead. The living Constitution has become part of the political fight over the appointments of the Supreme Court, for it is clear that Republicans like Reagan, when appointing Rehnquist as Chief Justice, wanted him to strictly interpret the Constitution, whilst Obama openly supported the living Constitution in his book, The Audacity of Hope, when he said, "Ultimately, though, I have to side with Justice Breyer's view of the Constitution, that it is not static, but rather a living document, and must be read in the context of an ever-changing world." However, even Obama recognised the views of those who support original intent, insofar as parts of the Constitution that state the minimum age of a president or the rule of the Electoral College is clear-cut and not open to interpretation. However, the real argument does revolve around phrases such as unreasonable searches and seizures, as it appears in the Fourth Amendment, and the Due Process and Equal Protection Clause of the 14th Amendment. For those who subscribe to the living document approach, the following two phrases are enough to guarantee individual rights of privacy, even though no such phrase appears in the document. Original intent advocates say that this is precisely what is wrong with such an approach, and it is a dangerous approach as it gives huge power to unelected judges. For former Justice John Paul Stevens, it is an equal danger intending to reading, say, the Establishment Clause of the First Amendment rigidly, as if it was frozen 220 years ago. And that is equally as dangerous as it would mean not responding to the changing realities of society. Failure to do this would straitjacket the Constitution and arguably make it less relevant than it is, and possibly have even seen it being ignored or totally rewritten rather than evolving. He might point out to the fact that in France has rewritten its constitution on at least 7 occasions, and on 3 occasions fought over them on the battlefield. He sees the Supreme Court as a safety valve, using the broad terms of the Constitution to allow society to adapt and survive. He points out how a rigid reading of the Constitution, like that of the Taney Court in the Dred Scott case, led to a civil war and the near death of the Republic and the Constitution itself. The living Constitution approach, he would say, is a very necessary one to the survival of the Republic. For most commentators, the real aspect of the living Constitution argument applies to the view that while most of the words have remained the same over 220 years, their meaning has changed by interpretive amendments to the Supreme Court. The Founding Fathers probably had no idea that a flag-burning case would go before the courts in 1991, and that the First Amendment, freedom of speech rights, would be used to protect this act of flag desecration. Proof that the Constitution is living lies in the way that Justice Brennan wrote in favour of flag burning. Even the decision recently to allow corporations freedom to spend what they want on election campaigns, which was fated by Conservatives and damned by Liberals, appears like a living Constitution ruling, as the Conservatives in the court appear to contradict their opposition to living document activism, so there are both Liberal and Conservative activists. Critics of this actually use the same argument that is used by those in support of a living or flexible Constitution, by saying that since the Constitution remains silent on the methods of interpretation, there is no place for saying that simply because it is not there, that future generations could somehow revisit it and put their own slant upon it. Another area where a constitution causes controversy surrounds the 8th Amendment, not so much in terms of declaring the death penalty unconstitutional, but over the living meaning of cruel punishments. Recently, the court has considered that in relation to executing juveniles, cruel and the use of lethal injections not cruel. Whether on the majority or minority, it could be said that in this respect the Constitution is living, as it involves interpreting what this phrase means in light of changes in society, with respect to who should be executed and what methods should be used. It would appear that, as Anthony Bennett states, although the likes of Scalia and Thomas might adopt an originalist position against the living or flexible document idea. The fact is that via their rulings, the Supreme Court has and continues to amend the Constitution, and thus the conclusion must be that the Constitution has been treated, even by some conservatives, as a living document. The caveat to this will lie with the political balance of the Supreme Court, but even with the current court containing a majority who claim to subscribe to the original intent school of thought, the weight of cases on issues such as free speech, Reno v ACLU, on internet freedom, freedom of religion, and Engel v Tell, the momentum lies with the living document view.